So back in the late 90s, two things happened to me. One was that I worked for a CASA organization. CASA, C-A-S-A. Some states have these, some counties within states have CASAs if the county chooses to invest in it. A CASA is a court-appointed special advocate for children who are wards of the court or wards of the state. So I was involved in many parental terminations. Parental terminations at the will of the parents and against the will of the parents, depending on the circumstances. So I was involved in these terminations. I saw that parents can terminate their rights to their children or can have their rights terminated to their children. The other thing that happened to me was that this is about the time that I did a search for my biological origins, because as some of you may remember, I am an adoptee. So I went through the whole process of reunification with my biological parents, and it was a very, very interesting experience, to say the least. But one of the things that I found out was that my biological father had terminated his parental rights to me before I was ever born. So that tipped me off in another way in life, in that, wow, a parent can just disown their child for whatever reason. A parent can just disown their child. You can cut your legal ties with your offspring. So anyway, I've been hearing this argument recently in regard to abortion or not abortion, that if a woman chooses to go ahead with a pregnancy that the man that is the father of the child does not approve of and doesn't want to have any part of and certainly doesn't want to pay child support for, he should be able to choose to not pay child support, that he shouldn't have to pay. I think I even heard Dave Chappelle say this. And I'm thinking, well, of course he can choose not to pay. It's called termination of parental rights. So am I missing something? And I did look it up online to try to find clarity in the law. And I do see that in Florida, where I live, that a parent can terminate their parental rights and they have no further obligation to the child. And I know in Illinois, where I was born, that that is the case. I'm assuming it's still the case. But is there some kind of overarching federal law about this? I don't think so. It must be up to the states, but maybe it's the same in all the states. I mean, I think it must be, because I think that a parent in this country is able to terminate their rights to their children at any time, for basically any reason, really, if they just don't want to parent them. You think a mother that doesn't want her baby, that goes along with the pregnancy, follows through with the pregnancy, gives birth, but doesn't want the baby, that they're going to force her somehow to care for this baby or to financially support the baby? No, they're going to present her with termination of parental rights, articles for adoption, leaving the child up for adoption. If one parent or two parents abandons the child, that child is eligible for adoption by either one more parent or two more parents. So anyway, I just don't understand this argument that, I haven't heard any women say it, but I've heard men say it, that if the woman chooses to go ahead with a pregnancy that he doesn't approve of, that he shouldn't have to pay. Well, he doesn't have to pay. It's called termination of parental rights. And maybe that's callous. Maybe people feel like that's immoral, but we're not talking about callousness or immorality. We're just talking about law and practicality. And the practicality is that any parent that wants to terminate their parental rights to their child in this country can. But if you have any other information for me, I'm always willing to listen. I'm always willing to learn and adjust my understanding of things. So thanks for listening. Have a good day.